Hello, everyone. Today we are going to see what are the new amendments that were made to the Code of Criminal Procedure 1898. So we're gonna study about the Code of Criminal Procedure, Second Amendment Ordinance 2025. So the first amendment is to Section 32. Section 32 is about sentence which magistrates may pass. So this document actually is showing that the previous punishment that were allowed by the magistrate give, for example, 10,000 taka, 5,000 taka, or 2,000 taka, are increased to 5 lakh taka, 3 lakh taka, and 2 lakh taka. So this is what the point number two is talking about. It's talking about section 32. Now, moving on to section 46, point number three, which talks about amendments. Actually, it's adding more section to the section 46. So section 46 is about arrest how made. So previously it was very concise and now it's more descriptive and it's more specific as to how arrest will be made. And this is made by adding section 46A, B, C, D, and E. So let me highlight it. So let's read section 46A. Procedure of arrest and duties of officer making arrest. In making an arrest, the police officer or other person making the same shall, point number A, bear an accurate, visible, clear identification of his name, which will facilitate easy identification. Disclose his identity, and if demanded, shall show his identity card to the person arrested and to the person present at the time of arrest. Prepare a memorandum of arrest which shall be tested by at least one witness who is a member of the family of the person arrested or a respectable inhabitant of the locality where the arrest is made, and where no such witness is available, the reason thereof be recorded in the memorandum. Countersigned or thumb impressed by the person arrested if not refused by him. Point number D, intimate where the accused is arrested from a place other than his residence to a family member, relative, or a friend nominated by the arrested as soon as practicable, but not later than 12 hours from the time of such arrest, notifying the time and place of the arrest and the place of custody. Point number E, ensure if any mark of injury is found on the body of the person arrested, the examination and first aid treatment of the person by the medical officer or registered medical practitioner, as the case may be, in accordance with section 46E, obtain a certificate from the attending medical officer or practitioner and record the reasons for such injury. Point number F, allow the person arrested, if he so desires, to consult a lawyer of his choice or to meet any of his nearest relation, preferably within 12 hours of such arrest. Moving on to section 46B, which talks about entry of arrest in official register, general diary, and providing information relating to arrest. Subsection 1 of section 46B, in an entry shall be made in the official register by the officer making the arrest, stating the ground of arrest, the name of particulars of the informant or complainant, the name and particulars of the relative of the friend of a friend or friend, as the case may be, to whom information about the arrest has been given, and the name and particulars of the officers having custody of the arrested. Subsection 2, every arrest made within the jurisdiction of a police station shall be entered forthwith in the general diary of such station, and where the officer making the arrest is not attached to the said police station, he shall immediately, after making such arrest, cause a copy of the Memorandum of arrest to be furnished to the officer in charge of the said police station, who shall thereupon cause an entry thereof to be made in the general diary. Subsection 3, the officer responsible for maintaining the register or the general diary under subsection 1 and 2 shall on demand be bound to furnish information relating to such arrest to any relative, friend, or neighbor of the person arrested. Now moving on to section 46C. Designated police officer for maintaining and displaying information of arrest. District superintendent of police in every district or police commissioner in every metropolitan area, as the case may be, shall designate a police officer not below the rank of an assistant sub-inspector of police in every district or metropolitan headquarters and in every police station for maintaining the information regarding the names and addresses of person arrested and the nature of the offense for which they have been arrested. And such information shall be prominently displayed, preferably in digital form, at every police station and at the district or metropolitan headquarters. Section 46D, Health and Safety of arrested person. It shall be the duty of the person having custody of an arrested person to take reasonable care of his health and safety. Section 46E, examination of arrested person by medical officer. Subsection 1, when any person arrested appears to be sick or bears any mark of injury, he shall soon after the arrest is made be examined and provided with the first aid treatment by medical officer of a government hospital. And if such medical officer is not available by a registered medical practitioner, provided that where the arrested person is female, the examination of her body shall, if practical, be conducted by or under the supervision of a female medical officer, a female medical practitioner, or in the presence of a female staff nurse or a female attendant, as the case may be. Subsection 2, where the examination and treatment are conducted under subsection 1, a certificate along with report of such examination and treatment shall be furnished by the medical officer or registered medical practitioner, as the case may be, to the concerned police officer, as well as to the arrested person and to a person nominated by him. Subsection 3, where an arrested person being sick or injured is produced before the magistrate may pass necessary orders for such medical treatment, provided that where the arrested person is severely injured or sick in manner which requires his admission into a hospital and renders his physical production before the magistrate impracticable, he may be produced before electronic video linkage. He may be produced through electronic video linkage subject to satisfaction of the magistrate and to such terms as the magistrate may determine. Now, point number 4, Act number 5 of 1898, Section 51 is সংশোধন. So Section 51 talked about search in previous. Basically, Section 51 talks about search of arrested persons. In this case, what will happen is after him in section 51 এর শব্দের উল্লেখিত হিমের শব্দটির পর এগুলো add হবে and this will be added like and where any article is seized from the arrested person, the officer shall prepare a list in the presence of the witness and obtain his signature if applicable and shall serve a copy thereof to the arrested person or to any person nominated by him. So this is 51. So 51 is as it is, and some addition is being made by this amendment. Point number 5 is section 54. পরিবর্তে নিম্ন section 54 প্রতিস্থাপিত হইবে যথা. So section 54 will be this one. The previous section 54 will not be there. So section 54 is when police may arrest without a warrant. So there were 9 points previously where police could arrest without warrant. Now let us see what are the new amendments in this place, in this document we get. So subsection 1 is any police officer may, without an order from a magistrate and without warrant, arrest Firstly, any person who commits in the presence of a police officer a cognizable offense. Secondly, any person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine, if the following conditions are satisfied, namely, point number one, the police officer has reason to believe on the basis of such complaint, information, or suspicion that such person has committed the said offense. And point number two, the police officer is satisfied that such arrest is necessary A, to prevent such person from committing any further offense. Point number B, for proper investigation of the offense. Or point number C, to prevent such person from causing the evidence of the offense to disappear or tampering with such evidence in any manner. Or point number D, to prevent such person from making any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or the police officer. Or point number E, as unless such person is arrested, his presence in the court whenever required cannot be ensured, and the police officer shall record while making such arrest his reasons in writing, provided that a police officer shall, in all cases where the arrest of a person is not required under the provision of this subsection, records the reason in writing for not making the arrest. Thirdly, any person against whom credible information has been received that he has committed a cognizable offense punishable with imprisonment for a term which may extend to more than 7 years, whether or without fine or with death sentence, and police officer has reason to believe on the basis of that information that such information person has committed such person has committed the said offense, basically. Fourthly, any person having in his possession without lawful excuse the burden of proving which excuse shall lie on such person any implement of housebreaking. Fifthly, any person who has been proclaimed as an offender either under this code or by order of the government. Sixthly, any person in whose possession anything is found which may reasonably be suspected to be stolen property and who may reasonably be suspected of having committed an offense with reference to such thing. Seventhly, any person who obstructs a police officer while in execution of his duty or who has escaped or attempts to escape from lawful custody. Eighthly, any person who is reasonably suspected of being a deserter from the armed force of Bangladesh. Ninthly, any person who has been concerned in or against whom reasonable complaint has been made or credible information has been received or a reasonable suspicion exists if he has of his having been concerned in any act at any place out of Bangladesh, which if committed in Bangladesh would have been punishable as an offense and for which he is under any law relating to extradition or otherwise liable to be apprehended or detained in custody in Bangladesh. Sorry. Tenthly, any release convict committed a breach of any rule made under section 565, subsection 3. 11thly, any person for whose arrest or a requisition has been received from another police officer, provided that the requisition specified the person to be arrested and the officer or other cause for which has the arrest is to be made and appears therefrom that the person might lawfully be arrested without a warrant by the officer who issued the requisition. Subsection 2, no police officer shall be arrested. Sorry, no police officer shall arrest a person under this section for the purpose of detaining him under any law providing for preventive detention. So I'm going to keep it till now. So I'm gonna continue in another video from point number 6. It's already been a long video, so I'm gonna start the rest in the next video. So thank you for listening, everybody. We're gonna move on to the next part really soon.